minutes, and then we'll have 15 minutes for Q&A at the end if necessary. And if you want to email me or chat with me during the session or ask questions, please put them in the Q&A box. I'm going to be monitoring that as I go along, and I'll either answer questions along the way or at the end. A little about me: I'm a independent arbitrator at Lerners and a partner at Lerners and an arbitrator at Arbitration Place. And the purpose of this series has been to cover some topics that I kind of wish I'd known a long time ago. It's easy to get a lot of the principles, but the practical elements, how to apply the principles, is a lot more difficult to learn about. And so that's what these sessions are focused at. After this session, as always, you'll get a recording of the session and a list of resources that I mentioned, so you can take a look at them. So today's session is called Evidence in Arbitration. It's all about fairness and equality. And if you only have 5 minutes to spend, that's all you need to know about evidence in arbitration. But I'm going to give you a little bit more detail for those who are gonna stay. Generally, people talk about the rules of evidence in arbitration being relaxed, but there's not really a lot talked about what that means. So I'm going to try to put a little meat on those bones. But before I get there, I just want to make a little plug for something that I'm offering between now and the end of April. I know that we all take seriously our professional responsibilities to serve members of the public in a meaningful way. And so this year, I'm trying something new. From now until the end of April, I'm going to offer my services as arbitrator for a flat fee for an expedited procedure for matters valued up to $500,000. And my flat fee starts at $5,000 for small matters. And we can get small matters done within a very short time, a couple months tops. Or I will arbitrate some interlocutory matters. I just heard at one of our practice group meetings last week, I think it was, that the list to get a half-day motion before an associate justice is now a year. So if you want to get some of these interlocutory matters dealt with and jump the queue to get on the trial list, feel free to call me and we can talk about that as well. So consider that, pass the information along to your friends if you think it would be, and your colleagues if you think it would be useful. So now we're going to get into the substance of today's topic, evidence in arbitration. And the first issue really is where to look for guidance on the evidentiary principles relating to arbitration. So, and I'll explain why the foundational principles of fairness and equality are absolutely essential. So the first place to look is mandatory legislation, the Arbitration Acts, domestic or international, then the contract of the parties, and then the order of the arbitrator, and finally some soft law, some of the guidelines that are relevant, and some of those I've talked about earlier in this series. So let's start first with the mandatory legislation. There are common themes in the legislation, but they're not identical. So as always, if you're looking at a particular matter, you simply must go to the legislation that's relevant to the seat in respect of that matter. I'm going to refer mostly to the Arbitration Act because I'm familiar with it and because otherwise we'd be talking for a long period of time. But there are other provinces that have similar legislation in Alberta, Manitoba, Saskatchewan, New Brunswick. And the new BC Arbitration Act has some developments which make it slightly different, but it's very similar to the principles that are found in Ontario and the other related jurisdiction. Then there is, of course, the International Act, which is for the most part in Canada, the model law. And the second issue is the contract of the parties as a source for the relevant evidence and procedure. And some provisions of mandatory legislation can be opted out of, but not all of them. So for example, fairness and equality cannot be opted out of. Extensions of time, set-asides of the award, declarations of invalidity of the award for fairness, unfairness grounds, and enforcement of the award. None of those can be opted out of, but other provisions in the legislation can be. Many of the domestic acts provide for appeals, and there is no appeal, as most of you will know, from a model law jurisdiction legislation. In the domestic legislation, you can contract out of appeals, and that's a merits issue. I'm not going to be talking about that today. So we're really focusing on evidence and procedure. The next source of requirements for evidence can be found in the order of the arbitrator. The arbitrator has broad jurisdiction to decide the procedure, and subject to whatever may be in the institutional rules, that obviously must be fair to meet the requirements of fairness and equality that are requirements in the legislation. And then finally, the soft law. And I'm going to talk about the IBA rules of evidence again today. I've talked about it in a number of the sessions we've had because it spans quite a wide array of issues. And it is, if you haven't already done it, a must-read document in both domestic and international arbitration. And then, of course, there are the rules that the parties agree upon or the tribunal orders. And all of those are sources of potential evidentiary rules that you must need to know in your arbitration. So let's start at the beginning. Fairness and equality, which, as I said, is mandatory in the legislation. So, for example, in the Arbitration Act, and this will demonstrate some of the slight variations in the legislation. In the Ontario Act, there is a specific provision, section 19, that talks about equality and fairness and says that in an arbitration, the parties shall be treated equally and fairly, and each party shall be given an opportunity to present a case and respond to the other party's case. Similarly, in BC, the general duties of an arbitral tribunal under section 21, an arbitral tribunal must treat each party fairly, give each party a reasonable opportunity to present a case and to answer any case presented against it, and strive to achieve a just, speedy, and economical determination of the proceeding on its merits. Under the UNCITRAL model law, Article 18 talks about equal treatment of the parties. Parties shall be treated with equality, and each party shall be given a full opportunity of presenting its case. Why the focus on fairness and equality other than, for example, due process requirements? This is important because the remedy for failure to ensure that the parties are heard or provided with fairness and equality rights is that the award may be set aside. And so while there is an appeal process, which may or not apply depending on the parties' agreement and the legislation, there is, regardless of whether you're doing an arbitration under the model law or the domestic legislation, a right to have the award set aside on the basis that the process was somehow unfair. And there is usually a list of examples of circumstances in which the process has been unfair. Because of, and this is just a bit of a diversion, because of SATVA, a case we all know about from the Supreme Court of Canada, it has narrowed, potentially, the circumstances in which an appeal may be raised on the merits. And what SATVA essentially said is that it's the rare case where in matters of contract interpretation, which is basically what arbitrators do for the most part in commercial arbitrations, can give rise to an appeal only where there's an extricable error of law. And that's because the contract interpretation process is a process in which facts and law are interpreted. And so because of this narrowing, I often see, and you often see in the case law, parties both appealing and seeking to set aside an award. And so you'll see that very often, but they are very two distinct remedies. Sometimes you'll see an argument that a procedural flaw is an error of law. And while those don't succeed very often, you can see the creativity that might give rise to that kind of an argument. So if we look, for example, at the Ontario Arbitration Act, and it talks about when a set-aside may be brought, it's first of all brought on a party's application, and the court may order a set-aside on the following grounds. The applicant was not treated fairly and equally and was not given an opportunity to present or respond to another party's case, or was not given proper notice of the arbitration or the appointment of the arbitrator, or the procedures in the arbitration did not comply with this act. Under the new BC Act, applications for setting aside of arbitral awards, again, an application to the BC Supreme Court, where the applicant has not been given a reasonable opportunity to present its case or to answer the case presented against it, so long as it hasn't waived its right to object. And under the UNCITAL model law, the application for setting aside is the exclusive resource against an arbitral award, and recourse may be made only by application for setting aside if the party making the application furnishes proof among the grounds that the party making the application was not given proper notice of the appointment or was unable to present its case. And so it makes sense that there would be some flexibility in an arbitration, and why arbitral tribunals may be somewhat more flexible or lenient in letting in evidence to ensure that the process is fair because of this potential remedy. So, for example, if you look at the overarching requirement that the arbitration be fair and provide the parties with an equal opportunity to present and respond to their case, you can see why evidentiary rules like the rule in Brown and Dunn may very well apply. But the rule in Brown and Dunn is essentially a fairness rule, that it's not fair to make a finding against a witness without an opportunity for that witness to answer the potential adverse finding. And it doesn't allow parties to cross-examine a witness. It does allow parties to cross-examine a witness, for example, after an arbitrator asks questions. And you do see arbitrators asking questions of witnesses more frequently in arbitrations than in trials. And so the protection that parties have against that is that their counsel will have an opportunity to ask questions after the tribunal has asked questions, and of course, address those issues in argument. If the award deals with matters that are beyond the scope of the arbitration clause, that becomes a jurisdictional issue. That could be a procedural issue, a problem which may give rise to a set-aside, because again, the arbitration limits were defined by the parties' arbitration agreement, and the arbitrator's decision went beyond that agreement. Or another example is the arbitrator did not follow the process agreed upon by the parties, either in their agreement or in the rules that the parties chose. So if we look at the procedure that the parties may be required to follow or may agree to be followed, we see how that is intimately linked with the procedure and the fairness. So, and why is this? We all know that the rules of court do not apply to arbitrations unless the parties choose that option. And there are specific institutional rules that are designed for arbitrations that parties can use, and that will often provide comfort to people that there's some structure in to the process and to the arbitrator's running of the arbitration. There are in many cases no specificity about rules in the original party's arbitration agreement, and sometimes once the dispute arises, the parties will agree on rules of procedure, but if they don't, it may be that the arbitrator will impose rules, always after submissions by the parties, but sometimes the arbitrator simply makes decisions on the process as they arise. And that's one of the common threads we see in arbitrations. It's that procedural flexibility that allows the procedure to be determined by the specific issues that are raised in that arbitration. The arbitrator clearly has a role in determining admissibility, relevance of evidence, materiality, and weight. It allows the fact that there may be some constraints on the arbitrator's ability to design a process is obviously consistent with party autonomy, but it also gives the arbitrator the power to make decisions that the parties haven't contemplated in order to keep the arbitration moving. So although tribunals do not have inherent jurisdiction in the way that courts do, and that their jurisdiction is defined by the parties' agreement and the issues that they raise to be decided by the arbitrator. There is a concept in which the arbitrator has the ability to ensure the integrity of the process and to control the process. And so there are powers that are not expressly found in either the legislation or in the parties' agreement that the arbitrator may need to exercise. And it only makes sense because if an arbitrator is essentially retained to decide a party's dispute, it certainly can't be the case that that the arbitrator doesn't have the powers when something unexpected arises to decide the dispute, or arbitrations would be simply hung. Another issue about fairness and equality is that an arbitration may take place in writing, but so long as one party asks for an oral hearing, the oral hearing must take place. And there's a recent decision of the Ontario Court of Appeal called Optiva, OPTIVA versus Tibet-Tel, 2022 Ontario Court of Appeal 646, in which the court says that an oral hearing doesn't necessarily have to be an evidentiary hearing in order to meet the fairness and due process requirements. And one of the reasons for that is the court says that, for example, a summary judgment proceeding or an application will not involve viva voce evidence, but it clearly meets fairness requirements. And so an arbitration which proceeds strictly by writing on the consent of the parties will not run afoul of fairness and due process. So let's go back to the relevant legislation so you can get a flavor of how the legislation deals with this procedural issue. So Ontario Arbitration Act Section 20, very easy. The arbitral tribunal may determine the procedure to be followed in accordance with this act. And then it talks about evidence, and this is a provision that's quite unique in Ontario. Sections 14, 15, and 16 of the Statutory Powers Procedure Act apply to arbitrations with the necessary modifications. So Section 14 applies, the privilege against self-incrimination. Section 15 applies, what is admissible in the hearing. The tribunal must admit everything relevant, but may exclude anything which is unduly repetitious, and privileged evidence is not admissible. So this suggests, for example, that the tribunal may accept hearsay evidence, and whether it gets accepted will be based on relevancy, weight, etc. And finally, Section 16 of the SPPA says that an arbitral tribunal may make notice of facts. So what we would call judicial notice in the court context. The current BC legislation, Section 28, it says, a tribunal may decide all evidentiary matters, including the admissibility, relevance, materiality, and weight of the evidence, and may draw such inferences as the circumstances justify. Unless otherwise agreed by the parties to the arbitral proceeding, the arbitral tribunal is not required to apply the law of evidence other than the law of privilege. So that's expressed very clearly in the BC law. Unless otherwise agreed by the parties to the arbitral proceedings or directed by the arbitral tribunal, the direct evidence of every witness must be presented in written form. And that's a novel part of the new legislation, but as I'll talk about later on, that model can be used in any arbitration. Then the procedural powers of the tribunal under the BC law. Subject to this act and any agreement between the parties, the tribunal may establish procedures and may make procedural orders for the conduct of the proceeding. That includes making orders respecting statements or position or pleadings, including when they should be delivered, their form and content, and whether amendments are allowed. Subject to privilege, requiring a party to produce records or information, the form in which evidence and argument are presented, allocating hearing time between the parties, excluding witnesses or potential witnesses from attending any part of an oral hearing, and the examination of witnesses under oath or affirmation. So these procedural rules really have a bearing on specific evidentiary requirements. The UNCITRAL Model Law, Article 19, determination of the rules of procedure. The parties are free to agree on the rules of procedure subject to the provisions of this law. Failing such agreement, the arbitral tribunal may conduct the arbitration in such manner as it considers appropriate. The power conferred upon the arbitral tribunal includes the power to determine the admissibility, relevance, materiality, and weight of any of the evidence. Article 24, subject to any contrary agreement by the parties, the tribunal shall decide whether to hold oral hearings for the presentation of evidence or for other oral argument, or whether the proceedings shall be conducted on the basis of documents or other materials. However, unless the parties have agreed that no hearing shall be held, the arbitral tribunal shall hold such hearings at an appropriate stage of the proceeding, if so requested by a party. So you can see that in those three legislative provisions, there are slight differences. And my belief is that despite those slight differences in wording, there is really no likely difference in the arbitrator's powers or the party's right to fairness, despite those differences. So how do all these principles apply in practice? And how is this different than litigation? And again, one of the benefits is the use of specific institutional rules creates a process that is directly relevant and created for arbitration. So the rules invariably provide help in devising process and evidentiary issues. And all of these rules contain provisions that talk about what happens when there's a conflict between law and the rules. And invariably the mandatory law, of course, applies. But the ADRIC rule, for example, rule 4.7, the arbitrator may conduct the arbitration in any manner it considers appropriate, must treat each party fairly and give a fair opportunity to present its case, must strive to achieve a just, speedy, and cost-effective determination, etc. The tribunal may be guided by the rules of evidence that apply in a court proceeding, but is not required to conform to them. And of course, the tribunal must determine the admissibility, relevance, materiality, and weight, and provides that a tribunal expert is permitted. And this is something you see quite commonly in the rules and in some of the guidelines. And that is not just permitting party appointed experts, but allowing the tribunal itself to appoint an expert to provide the tribunal guidance. And there are all sorts of procedures that protect the parties in that situation. And I'll deal with those in a moment. The VANIAC rules, the Vancouver International Arbitration Society, similar provisions. The IBA rules for taking evidence in international arbitration. You've heard me talk about the IBA rules of evidence many times in these sessions, and it's got application here. It works also for domestic arbitration, as I've said. Article 8, evidence may be limited if it's irrelevant, immaterial, unreasonable, burdensome, duplicative. And Article 9, the tribunal determines admissibility, relevance, weight, materiality, considering procedural economy, proportionality, fairness, or equality of the parties. And what this results in is sometimes a more interventionist and active tribunal than you often see in the court system, because of this idea that the tribunal will control the process and give the parties an opportunity to meet the case. If there's an issue that the arbitrator is troubled with or has specific questions about, by asking those questions, the arbitrator is giving notice to the parties that this is an issue of interest to the tribunal and gives the parties an opportunity to address it. So it means that the arbitrator may take a somewhat different role than many people experience in a court with a judge. So let's turn to a related topic, which is pleadings, because pleadings may contain evidence, which is not something that we're used to in the court proceedings. And sometimes what we call pleadings, and I kind of put it in quotation marks because that is a court litigation term, but these documents we call pleadings may be called statements or memorials or similar language in the particular under the particular rules. And they may contain documents that the parties rely upon that may be either agreed upon by the parties or by the tribunal and may contain legal arguments. So you may see evidence attached to the pleading. And again, one of the reasons for that is that in arbitration, the plan is to have parties put their cases very early on in the process. So everybody understands what's really important, as opposed to what we often see in litigation pleadings, which is a very broad brush pleading that keeps all doors open until examinations for discovery and documentary production, when parties really understand what the issues are about. That is one way to shorten the process of arbitration, which is to make sure that the legal issues are identified very early on. So we see in the Ontario Arbitration Act, for example, the parties' statements, and that's what a statement of claim or a claimant's claim is called under the Arbitration Act, shall indicate the facts supporting their positions, the points at issue, and the relief sought, but may submit statements and with their statements, documents they consider relevant, or may refer to the documents or other evidence they intend to submit. Under the UNCITRAL model law, within the time period agreed by the parties or determined by the tribunal, the claimant shall state the facts supporting its claim, the points at issue, and the relief or remedy sought, and the respondent shall state in defense in respect of these particulars, unless the parties have otherwise agreed to the required elements of such statements. The parties may submit with their statements documents they consider to be relevant, or may add a reference to the documents or other evidence. So this is something we see in both domestic and international arbitration. Then how does expert evidence get treated in international arbitration? So the legislation, as I've said, and the rules provide for the appointment of an expert by the arbitrator. And the parties participate in that process. So if the arbitrator intends or wishes to have expert evidence or an expert appointed by that tribunal, that will only occur if the arbitrator advises the parties and gives them an opportunity to make submissions on whether such an arbitrator should be appointed. And of course, the cost issue later gets dealt with as part of the cost of the arbitration if such an expert is appointed. And the parties also have an opportunity, obviously, to cross-examine that expert or make submissions on whether that expert has the appropriate expertise, etc. later on. But the purpose of the tribunal getting an expert may be something that the parties support if it is a cost savings measure, and there are a few discrete issues, for example, that the parties disagree about. The Ontario Arbitration Act contains a provision that the tribunal may appoint an expert to report on specific issues, and the tribunal may require the parties to give the expert any relevant information or to allow the expert to inspect property or documents to allow that expert to do the job. And at the hearing, the Ontario Act says, the expert shall, after making the report, participate in a hearing in which the parties may question the expert and present the testimony of another expert on the subject matter of the report. The BC Arbitration Act provides for similar rights and for a similar ability of the arbitrator to appoint an expert. And the duty of the expert under the BC Act is explicitly set out. An expert appointed by one or more of the parties or by the tribunal has a duty to assist the arbitral tribunal and is not to be an advocate for any party. Very, very common, not surprising. And the UNCITRAL law also talks about an expert appointed arbitrator to advise the tribunal on specific issues. and unless otherwise agreed by the parties, if a party so requests, or if the tribunal considers it necessary, the expert shall, after delivery of his or her written or oral report, participate in a hearing where the parties have the opportunity to put questions to the expert and to present expert witnesses in order to testify on the points made. So very similar rights in all the legislation. When there is more than one party appointed witness, so this is not the tribunal appointed witness, but where there are party appointed witnesses, there are lots of guidelines on a procedure that can work very well in arbitrations. And there are two resources, which obviously I'll send to you at the end of this session, that provide a really helpful procedure. The first is the IBA rules on the taking of evidence in international arbitration. And the second is the Chartered Institute protocol for the use of party-appointed expert witnesses in international arbitration. And I emphasize again that these can be very effective in domestic arbitration as well. And I consider both of them must reads if you're considering expert appointments in arbitrations, because what they describe is kind of a meet and confer process, which I think is gradually creeping into courtroom litigation, but is very well established in arbitration. And the way that that meet and confer process, of course, can be different depending upon what the parties agree or what makes sense for the actual proceeding. But essentially, the parties get together and either before or after they've prepared a final report, they consult about where they have a common view and a common opinion and where they differ and why. And as a result of that meeting, they may require additional information, inspections of property, etc. And then they deliver together a report on what they agree with and what they don't. And you can imagine how useful that process is, where cases can turn on what is commonly called the battle of the experts. And what it does is it manages to streamline the issues so that the parties are focusing really on what's in dispute, and the tribunal understands what is not in dispute and has an opportunity to, of course, ask questions of the tribunal. Now, it's common in the arbitration context for expert witnesses in particular to hot tub, as it's called. And that occurs when tribunal experts or party appointed experts testify on a panel. And the Arbitration Act of Ontario allows panels of witnesses to testify, and it's particularly apt where there are experts, because that allows parties and the tribunal to ask specific questions of experts and have them comment on each other's answers and agree or disagree as the case may be, which again helps narrow the issues, explains the issues. So the Chartered Institute protocol is essentially a more detailed addendum to the IBA rules of evidence. So you really start with the IBA rules on expert evidence, and then you go to the Chartered Institute protocol. And one of the things that it offers is a much clearer duty of arbitrator about all of the reasons that the arbitrator, the expert can hold himself or herself out as independent, and also provides a detailed list of the elements of the report, including the instructions that and the parameters of the job that the expert witness was asked to consider. And interestingly, the Chartered Institute protocol explicitly finds that the notes and initial drafts of the expert are privileged. And none of those documents gets produced unless obviously you can show an exception to privilege, etc. But that cuts down on a lot of the wrangling that takes place in the court proceeding about changes of reports and all that kind of stuff. So let's talk about how all of this fits together, how you can achieve the benefits of arbitration, which shorten the process, require more cooperation in some cases, particularly among experts, and allow for due process. And so there is something which has been called evidence first arbitration. I talked about it a little bit in the session that I did on the first procedural meeting. And it's a term that I first heard from arbitrator William Horton, who summarized a process that works very well in both domestic and international arbitrations, regardless of the amount at issue. And essentially, it means that parties have a full opportunity to be heard, a full opportunity to present their case, and it also saves time and costs. So let me tell you how it works. The sworn statements are essentially, or affidavits, are essentially the direct or examination or evidence in chief of the witnesses, including, in some cases, the experts. And those witness statements are exchanged very early on in the process, often right after the pleading stage. And that's essentially the opportunity for each party to put forward its case. And then those witness statements are either exchanged simultaneously with an opportunity for each party to respond to new issues or issues that need to be that they don't agree with in the original witness statement, or more commonly, there's an affidavit or witness statement, a response, a reply, a rebuttal. And again, the response and the rebuttal only dealing with new evidence that arose in the previous witness statement. There is always the flexibility, of course, for new evidence to be adduced upon application to the arbitrator, and if there are extraordinary circumstances. But what that means is parties know very, very early on what the case is about, and it obviates the need for oral discovery and documentary production in most cases, because the party's case is there in the witness statements or the affidavits. Where there is additional information needed, the first procedural meeting order will provide that the parties have a right to ask for more documents or information if necessary, but you can see that that kind of request is a very focused one, rather than production of every document that may be relevant. And similarly, if additional oral discovery is necessary, it can be done very quickly on very discrete issues. So that kind of process really meets all of the fairness requirements, and you can see how eliminating all of the lengthy discovery process, which in my view, and the view of many others, is where cases really get bogged down, and allows for that part of the process to be sped out with any loss of rights on the part of the parties. If there are interlocutory issues that come up, such as, I believe there's a particular document which the other side didn't attach to its witness statement and is necessary in order for me to properly answer my case, then those kinds of issues can generally be dealt with rather informally. If it's a document production issue, there's something called a red fern schedule, in which there are specific itemized requests, the reason for the document request, the relevance to the proceeding, and the reason why the other party has it and the requesting party doesn't. So you can see that really focuses the argument. Often these issues can be dealt with on a conference call with the arbitrator without any need of a formal notice of motion, etc. So all of the evidentiary needs and requirements are being met with this kind of a process, and yet it's much more streamlined. Then there's obviously an oral hearing if the parties request it, but in some cases that the arbitration will be decided simply on the exchange of that written evidence. However, if an oral hearing is requested by either of the parties, then you can see how you've shortcutted the hearing without shortcutting the due process rights. You've got the witness statements or or affidavits serving as examination in chief. Sometimes people will ask for about 15 minutes to warm up their witness on the witness stand. Again, that's not unduly time consuming. And then the other party will have an opportunity, of course, to cross-examine. But the reason that this format creates a real expediency benefits is because the cross-examining party obviously has a lot of opportunity to prepare for the cross-examination based on the witness statements or the sworn affidavits of evidence. So you get a much tighter, skilled cross-examination. And you also don't have a need for adjournments to allow for cross-examinations, to allow somebody to prepare. So you can see that all of these processes and all of these factors in this process allow for expedience, cost cutting, but it doesn't sacrifice the right of parties to state their case and to have an opportunity to respond to the other side's case, and to be dealt with fairly and equally. So the last topic I'd like to talk about then is the arbitration agreement and what parties can do to make sure that they have some control over the process and therefore the evidence. The arbitration agreement can obviously be done either post-agreement or pre-agreement. We're used to, for the most part, seeing arbitration clauses in the party's business conduct that gives rise to the dispute. But if post-dispute parties would like to enter into agreement that decides some of these procedural issues, that can be done. It's rare to see in the pre-dispute arbitration agreements a reference to arbitral rules, but you do see those on occasion. If the parties haven't done that, they may wish later on, once the dispute arises, to say, we'd like to have this dealt with under the ICC rules, whether it gets administered or not by the ICC. We'd like this done under the VANIAC, the ADRIC rules. And that is actually a way of providing structure to the arbitration, and parties may be able to agree on that if they can't agree on some of the substantive issues. But again, like all arbitration agreement drafting issues, draft carefully, because ambiguity in the drafting can give rise, obviously, to issues, including failing to identify a seat, which can make difficulty where you may have just decided on which rules you want to apply, but the relevant legislation that the tribunal is applying is subject to question. Other issues with, for example, multi-tier clauses that can create problems. These are usually done pre-dispute, and they often provide for some kind of a negotiation or mediation process before the arbitration takes place. And then the question becomes, if one party refuses to negotiate or get involved in the mediation, does that prohibit the other party from going to arbitration? And again, that is a matter of contract interpretation. So if the parties want to have some control over process, procedure, and evidence, the best place to do it is in some kind of an arbitration clause, whether it's pre or post dispute. So the last thing I have to say before I open it up for questions is that you can see the innumerable ways that an arbitration process can be structured to achieve a lot of the benefits parties are seeking. Speed and costs savings are the two primary ones, without sacrificing all the alterum partem requirements. And due process and fairness is absolutely protected, both by the agreement, by the legislation, but also by the possibility that if someone is not treated fairly, the arbitral award may be set aside for unfairness. And so evidentiary rules such as Brown and Dunn, hearsay, adverse inferences, and there are many other I'm sure you can name, are just rules of fairness. And you saw examples of provisions in the legislation and the various rules which said arbitral tribunals are not bound by the rules of evidence in court proceedings. And so that gives rise to some flexibility, but also protects the parties. So my next session will be on arbitration agreements, the good, the bad, and the ugly. And I'm going to address this mostly from a counsel perspective, because it's usually the case that counsel get a file and the arbitration agreement has already been drafted, and they need to then look at their parties' objectives and determine whether the arbitration agreement serves those objectives and whether it is ambiguous or not. And in many cases it is. And then if there is an interest in a post-dispute arbitration clause, I will give some pointers on that kind of drafting. So I will cover multi-tier arbitration agreements, the difference between admissibility and jurisdiction, which I hear all the time, and I think it's often misunderstood and misused, the law of the arbitration agreement versus the law of the contract. we all know about this principle of separability, but one of the consequences of that is that the law of the arbitration agreement may not be the same law as the business contract between the parties. And the current law about how to make that determination is actually quite difficult and not settled. What to do about pathological arbitration clauses if you're counsel. And finally, the problem of non-signatories. You've got a case in which you've got a number of parties that have an interest in or are common to the business dispute. However, they are not signatories to the arbitration agreement. Can they be made parties to the arbitration? What are the consequences if they can't? So those are the topics I'm going to cover next time. Today, of course, you'll get a recording of this session, a list of resources that I referred to. And again, reach out to me if you've got any questions about this session or anything else that I might talk about in future sessions. So I'm going to give a few minutes for questions to come in. I don't yet have any. Nothing's come in. So have a great day, and I'll see you next month on, I believe it's March the 9th. That's a Thursday at the same time. Have a great day.